Does a residential treatment facility operated by the Department of Corrections have to provide outside community-based opportunities to residents? To find out, you have to read Alcantara versus Annucci, but it's 20 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Alcantara versus Annucci. The citation for this case is 2024 New York Slip Opinion 02224, published by the New York Court of Appeals on April 25th of 2024. The issue in this case is whether the Department of Corrections has an obligation to attempt to secure outside community-based opportunities like educational, employment, and vocational opportunities in the community outside of a residential treatment facility such as Fishkill Residential Treatment Facility. To understand and appreciate the context of this case, it's a little complicated, the law you have to understand. Basically, if you're a sex offender, a person who's convicted as a sex offender has an obligation to comply with SARA, which is the Sexual Assault Reform Act. One of the obligations of SARA is that a convicted sex offender with certain conditions cannot live within 1,000 feet of a school or daycare center. As a result, a lot of people who, when they get out of prison, when they've served their time after their conviction, they can't find housing that's compliant with that SARA 1,000-foot rule. As a result, Penal Law Section 70.45 indicates, this is another area, says that after a person has finished their time that they're sentenced into jail, there's a period of post-release supervision. And for 6 months after they've served their time and while they're in post-release supervision, the Department of Corrections, whose job is to supervise a released prisoner, a convicted prisoner, may impose as a condition that they go to a residential treatment facility. That's under Penal Law Section 70.45. A residential treatment facility is defined by the law under Corrections Law 73. Okay, Corrections Law 73 says a residential treatment facility shall provide. Their job is to reintegrate a released prisoner back into society, and a residential treatment facility has to provide outside abilities, outside opportunities in the community. It's defined in Corrections Law Section 2 as a correctional facility consisting of a community-based residence in or near a community where employment, educational, and training opportunities are readily available. This is the important language. For persons who are on parole or conditional release, and for persons who are or soon will be eligible for release on parole, or who intend to reside in or near that community when released. Okay, so what are the facts in this case? The facts are that the plaintiffs are all here sex offenders, convicted sex offenders. They completed their incarceratory sentences, the part where they're in jail, and when they were ready to be released, they're subject to that SARA rule where they can't live within 1,000 feet of a school. It's very hard to find a location like that in New York City. And if they can't find a secure place that's SARA compliant, docs won't just won't walk them out to the door and say, good luck. They will transfer them, and they transferred these plaintiffs to the Fishkill Residential Treatment Facility. They took part of Fishkill Prison, and they turned it into a residential treatment facility as part of their post-release supervision for the first 6 months. They did this under Corrections Law 73 and a case that says they're allowed to do this called People versus Johnson from 2020. But plaintiffs are claiming in this case that the Fishkill Residential Treatment Facility doesn't provide them with any community-based employment, educational, or vocational training. And therefore, it's not satisfying that basic definitional requirement of a residential treatment facility. Rather, it's just like continuing in jail. They're in basically a prison. They can't go out into the community. There's no opportunities for them. And so they're saying the evidence in this case is that there's only 2 kinds of employment available for residents. These are not prisoners. These are residents of the residential treatment facility. One is as a laborer in a prison storehouse, which is inside the gates. And the second, which is as a janitor, which is inside the gates in the jail complex. There is internal programming that they've provided to the residents, but they say, well, that's not the same thing as an outside community-based programming and opportunity. So they sue. It goes to the Supreme Court first. They agree with the plaintiffs that DOCS is failing to comply with its obligations. And they also find that the internal programming is minimally adequate to satisfy their obligations. They appeal to the appellate division, and they say that DOCS is fine. They dismiss the plaintiff's case. They appeal to the Court of Appeals. And here, The Court of Appeals says they look at the statute defining what an RTF is, a residential treatment facility is, and they say an RTF is defined specifically by its external features, not just what's in the jail, not what's in the facility, but what's outside, the opportunities that are outside in the community. And they say that Corrections Law 2.6, which is what I described to you earlier, says that opportunities have to be readily available. These community-based opportunities must be readily available, and that's essential to the definition, to the functioning of a facility as a residential treatment facility. Because here, corrections can't control private citizens. They can't go into the community and say, you must accept these convicted felons, these convicted sex offenders as, into your programs, into your jobs. The Court of Appeals basically says that docs cannot categorically refuse to secure community-based opportunities. They also can't make them accept it. What they have to do is at least try. So they say that we conclude that docs' wholesale refusal to undertake efforts to secure community-based opportunities is a violation of the statute. At a minimum, they must undertake reasonable efforts to secure community-based opportunities. So they say docs is failing to even attempt to provide it. But at the end of the day, they also say, even though the plaintiffs are correct that docs is not providing what's required and they have to at least try, even after all of that, the Court of Appeals says there is minimally adequate internal programming to satisfy the obligations. They dismiss basically most of the case, but they do say the plaintiffs are correct that docs has to at least try to get community-based opportunities for the residents of an RTF. And that's the case of Alcantara versus Annucci. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.